by this time next week, the Supreme Court will have finished hearing oral arguments in the case challenging the constitutionality of the Patient Protection and Affordable Care Act. How important is this Supreme Court case on health care reform? Well, health care is such an important issue that Congress spent 1 year drafting and debating a bill that the court's going to consider next week. Health care has been a critical issue for so long in our country that in the last century, 9 different presidents have spent time, energy, and political capital fighting for reform. It's so important, the Supreme Court reserved 6 hours for oral argument over the course of 3 days to consider the Act's constitutionality. The last time the court dedicated that kind of time to any one case was in 1966. If I'm not mistaken, that's 46 years ago, when it considered Miranda versus Arizona. Nevertheless, not even the health care case is important enough for the Supreme Court to justify breaking its antiquated tradition and allowing cameras to televise the proceedings. So the American people are not going to have a chance to see and hear these historic arguments for themselves as they take place. I can't predict the outcome of the case, but I can tell you what to expect just outside the doors of the Supreme Court. It's a scene that we've seen over and over again for decades. Thousands will gather outside the court. Many are going to camp overnight, sleeping on the sidewalks in the hopes of getting one of about 200 seats available to the public. The vast majority of those wanting to see the Supreme Court argument on one of the most important cases of our time will be told, no, you're not allowed to come inside the court. We don't have room for you. In a democratic society that values transparency and participation, there can't be any valid justification for such a powerful element of government to operate outside the view of the American people. For too long, the American people have been prevented from observing open sections of the Supreme Court. Except for the privileged few, the VIPs, members of the Supreme Court bar, or the press, the most powerful court in our land, some might argue in the world, is inaccessible to the public and shrouded in mystery. I'm pleased to stand in the Judiciary Committee, with Senator Grassley, the ranking member of the Judiciary Committee, asking that the Senate pass our bipartisan bill that would require televising open Supreme Court proceedings. With the benefit of modern technology, the Supreme Court proceedings can be televised using unobtrusive cameras and the court's existing audio recording capability. Our bill respects the constitutional rights of the parties before the court, and it respects the discretion of the justices. The court can decline to televise any proceeding where the justices determine by a majority vote that doing so would violate due process of one or more parties. In our view, Senator Grassley and myself, this is a reasonable approach that balances the public need for information and transparency, the constitutional rights of those before the court, and the discretion of the judges. It's no secret that Senator Grassley and I have strong disagreements about the actual law that's going to be considered by the court. We've taken to the floor many times to explain our positions. Despite our disagreement on substance, Senator Grassley and I agree on a bipartisan basis to stand united in support of S. 1945 to finally bring transparency and openness to our Supreme Court. We're not the only members of this body who believe that these proceedings would produce greater accountability. In past years, the Cameras in the Courtroom Act enjoyed bipartisan support. The last sponsor of the act before he left the Senate was Senator Arlen Specter of Pennsylvania. This version of the bill, very similar to his own, has the support of Senators Cornyn, Klobuchar, Schumer, Blumenthal, Gillibrand, Harkin, and Begich. As Senator Grassley would note, Democrats and Republicans from both chambers have written to the Supreme Court asking it to permit live television broadcasts of the health care reform arguments next week. In November, Senators Blumenthal, Schumer, and I wrote the letter to the Chief Justice making the request, open the Supreme Court for this historic argument. Let America hear the argument made before the court and the questions asked by the justices in open court. Well, Chief Justice Roberts responded to our request last week, and it sounds like he sent the same letter, incidentally, to Senator Grassley. The Chief Justice informed us that the Supreme Court has respectfully declined to televise the health care arguments, but that the court would graciously offer an alternative. Here's the alternative: Now the court will post audio recordings and unofficial transcripts to the court's website just a few hours after the arguments are over. For that gesture, I guess we can congratulate the United States Supreme Court for entering the radio age. America entered the radio age 90 years ago. The Supreme Court is catching up with a delayed broadcast, audio only. But I think America deserves better. Decisions that affect our nation should be accessible by the people who are affected by those decisions, and they should be produced in a way that Americans can both see and hear. The day of the fireside chat is gone. The day of radio transmissions exclusively, those days are gone. Television and even the internet are the dominant media for communicating messages and ideas in modern America. It's not too much to ask the third branch of government at the highest level to share the arguments before the court with the people of America. Understand, there'll be hundreds of people present and watching this as it occurs. It isn't confidential or private. It's only kept away from the rest of America because this court doesn't want America to see the proceedings. The Supreme Court's an elite institution in our government. Every member of the Supreme Court went to one of two Ivy League law schools. Most of the clerks before the court come from one of 7 law schools. None of the current justices have ever run for public office. None of the current justices have ever tried a death penalty case. And the lawyers that appear before the Supreme Court are part of a small and exclusive club. Perhaps this limited exposure is why many on the court don't seem to fully appreciate the impact its decisions have on everyday America, and why the American people deserve to have more access to the court's public proceedings. Since the Supreme Court is the final word on constitutionality, on issues that impact every American, the American people should have full and free access to its open proceedings on television. Now, let's be clear about one thing. Our bill only applies to court sessions already open to the public. Supreme Court justices should be able to consult with each other, review cases, and deliberate privately. No one in this bill or otherwise is calling for those private deliberations to be televised. I believe that televising private deliberations or closed sessions of the court could cause harm to our judicial system. Our bill doesn't require it. I wouldn't support it. Open sessions, already open sessions of the court, however, where members of the public are already invited to observe, are a different matter. They should be televised in real time and widely available. Some who oppose our bill say that the elite cadre of seasoned lawyers with the rare opportunity to argue before the highest court in the land will grandstand in front of the cameras, risking their professional reputations and even their clients' cases. Some say the court's justices, who've been subjected to the most rigorous vetting process known to man and widely covered confirmation hearings, will suddenly shrink from asking tough questions because of the camera's glaring lens. I don't buy it. The experience of state and federal courts that have allowed their open proceedings to be televised proves these fears unfounded. While the federal courts of appeal have not yet permitted live cameras to broadcast all appellate proceedings, there was a 3-year pilot project in 1990 that assessed the impact of cameras in the federal courts. Listen to what happened as a result of that pilot program. At the end of the day, 19 of the 20 judges most involved concluded that the presence of cameras in the federal courts, quote, had no effect on the administration of justice, end of quote. Don't take my word for it. Kenneth Starr, former Solicitor General and independent counsel, supports our bill and said this: "This fear seems groundless. The idea that cameras would transform the Supreme Court into Judge Judy is ludicrous." For more than 30 years, state courts have broadcast their proceedings, and in fact, what they found is it hasn't detracted at all from the pursuit of justice. Every state in our nation permits all or part of their appellate court proceedings to be recorded for broadcast on television or streaming on the internet. Expanding access to the Supreme Court by televising its proceedings shouldn't be controversial. Public scrutiny of the Supreme Court proceedings produce greater accountability, transparency, understanding, and access to the decision-making in government. Congressional debates have been fully televised for more than 3 decades. There are people who follow C-SPAN broadcasts religiously. I know. I meet them regularly. As I've said in the Judiciary Committee, people will come up to me and say, one of your colleagues looks a little bit under the weather. Has he got the flu? Is he sick? They just, by observing C-SPAN or following the floor of the Senate and know each of us, they think on a more personal basis. They hear these statements, they listen to our debate, they feel better informed about their government. Wouldn't the same apply across the street in the Supreme Court? Opponents of our bill say the public will be misinformed because all they'll see are brief clips of the court's proceeding that can be misconstrued, leaving the public with the wrong impression. As I've said previously, this argument sounds a lot like an editorial from a few years ago, and here's what it said. Keeping cameras out of the Supreme Court to prevent people from getting the wrong idea is a little like removing the paintings from an art museum out of fear that visitors might not have the art history background to appreciate them. In 1986, Chief Justice Burger wrote the following words in the Supreme Court's Press Enterprise Company versus Superior Court opinion. These words are true today as they were in 1986. People in an open society do not demand infallibility from their institutions, but it's difficult for them to accept what they are prohibited from observing. The time has long since come for the Supreme Court, for the highest court in our land, to open its doors and allow the American people to finally observe its proceedings.